get you for the last 20 minutes, but I'm glad you are here.
Okay.
Okay, we'll start court at 2 o'clock. With the call of the calendar, please answer the calendar when it's called. And then once the entire calendar is called, we will start the oral arguments. Good afternoon, Justice Kern. How are you?
I am very well. How are you?
I'm doing fine, thank you. There you are. I can see you and I can hear you. Thank you. Good afternoon, Justice Kapnick. How are you today?
Okay. How are you today?
I'm doing fine, thank you. I can see you and I can hear you well.
Great. Thank you.
Good afternoon, Justice Kapula. How are you today?
I realized you didn't hear a word I said. In fact, I complimented you for the last 5 minutes, telling you how great you were. So I'll just, I won't repeat, but you'll know it's true.
Thank you. I can see you and I can hear you now.
Perfect, perfect. Thank you.
You're welcome. Good afternoon, Justice Singh. How are you today?
Can you hear me now?
Yes, I can.
I'll ask you again. How are you today?
I'm doing fine, thank you. How are you?
Good, thank you.
It is now 1:58. We will start court in approximately 2 minutes. We remind everyone to please keep your microphones muted if you are not speaking. The next voice that you will hear will be the voice of Justice Kapnick when she opens court and calls the calendar. A good afternoon to everyone.
Good afternoon. The Appellate Division First Department is now in session. Welcome to our virtual oral argument session for Tuesday, March 23rd, 2021. I would now like to call the calendar. The first case on the calendar is People versus Richard Rubiera. That case is submitted. Hershko versus Troutman Sanders, submitted. T.G. Children, I believe the appellant is here.
Correct. Yes, Your Honor.
Okay, and you have 5 minutes. You're the only one that's arguing today. The next case is Ader versus Ader. That is submitted. And just for the record, I am recused from that case, and Justice Renwick has been vouched in when they make the decision in that case. The next case is People versus Timothy Litch. That's submitted. Banks versus Bacopa, Inc., the appellant.
Good afternoon, Your Honor. Lisa Biscardi.
Okay, you have 5 minutes and 2 for rebuttal. And respondent?
Jason Steinberg, request 5 minutes.
Yes, you have 5 minutes in response. Thank you.
Thank you.
People versus David A., defendant, appellant.
Good afternoon, Your Honor. Amelia King-Musa for Appellant David A.
Okay, good afternoon. You have 5 minutes and 1 for rebuttal. And the respondent, People?
Christopher Peterson for the People.
Okay, and you have 5 minutes for response.
Thank you.
You're welcome. Darabont versus AMC Network. Appellant?
Yes, good afternoon, Your Honor. Oren Snyder for appellant.
Okay, you have 6 minutes and 1 for rebuttal. And the respondent?
Jerry Bernstein of Blank Rome for the respondent.
Okay, and you have 7 minutes. The next case is Century City Mall versus Waxman. Appellant? Mr. Lambert?
Good afternoon. I'm Tom Lambert from Lambert and Shackman for the appellant.
Okay, you have 6 minutes and 2 for rebuttal. And the respondent?
Good afternoon, Your Honors. John Kessler from Blank Rome on behalf of plaintiff respondent Century City Mall.
Okay, and you have 6 minutes. The next case is Carlyle Commodity versus certain underwriters. Appellant?
Good afternoon, Your Honor. David Yohai, Weil-Gotschel, and Manges for the appellants.
Okay, I think I gave you a little bit too much time on this case, but we'll see if you need it. All right, but I don't know if you will. 10 minutes and 3 for rebuttal. And the respondent?
Good afternoon, Your Honor. This is John Woods from Clyde & Co. on behalf of the defendant respondent.
Okay, we gave you 10 minutes also. We'll see how that goes. The next case is Linder versus United Metro. That case is submitted. The next case, Bergassi Group versus Allied World. Appellant?
Yes, Your Honor. Michael Tricarico of Kennedy's on behalf of the appellant, Allied World.
Okay, and you have 8 minutes and 2 for rebuttal. Respondent?
Good afternoon, Your Honor. Tarana Hashemi from the law firm of Gallo, Vitucci, and Clark for the respondent, Bergassi.
Okay, and you have 8 minutes to respond. Lewis versus Hallan Construction. Helen?
Good afternoon, Your Honor. This is Peter Simon on behalf of Hallan Construction Appellant.
Okay, you have 8 minutes and 2 in rebuttal. And respondent?
Yes, good afternoon, Your Honors. This is James Murphy from Virginia Ambinder for the respondent class. Thank you.
Okay, and you have 8 minutes. And the last case, East 103rd Street versus Mustache Inc. is submitted. So it looks like everybody that's supposed to argue was able to get on, and we saw you, so that's a good sign. Hopefully you'll be available when we get to your case. I just have to remind everybody to please keep your microphones on mute until your case is called. I also remind you that since we're doing the arguments this way, it's helpful if people don't talk over each other. everybody's sort of getting used to this, so I'm sure it'll be fine. And hopefully when you do have your chance to speak, you'll remember to unmute so then we can hear you. The first case for oral argument today is matter of T children, and we'll hear from ACS, the ACS attorney, Ms. Bedell. You have 5 minutes. Okay.
Thank you. Yeah. Good afternoon, Your Honors. Julia Bedell for the appellant ACS. Given that the other parties are not arguing today, I will attempt to keep my remarks here short. The family court erred when it excluded the one child, Asela, from the order of protection that it entered on behalf of all the other children. The respondent has never once denied that he
now, Ms. Bedell, it doesn't make any difference under the law that this particular child, Asela, was not even born when these events occurred?
No, Your Honor. Derivative neglect findings on behalf of afterborn children are somewhat common, and so that should not matter in this case, given the severity of the violence and the fact that the father was also violent with two of the children who was present. The risk maintains to this day. And because this risk still continues, there really is no reason why this one child is the only child who's not protected from such a risk.
Counsel, is the father, I know the mother wants the father to come back, but is the father excluded from the premises? And does that matter?
The father is excluded from the home under the order of protection, and that was the family court's primary basis for not finding him to be a person legally responsible in this case. And as we explain in detail in our brief, and as the AFC also explains in their brief, that was an improper determination by the family court, who focused on that one fact while not considering the many other facts that demonstrate that the father has a continued parental role in this family despite the order of protection. And indeed, it's sort of a circular argument to say that because the family court ordered him to not be in the home, that then it cannot find him responsible for derivatively neglecting this one child. Indeed, the father, again, has had many opportunities to deny being this child's parent, and he has never done so. He accepted service of the petition filed on behalf of this afterborn child himself personally in family court, and he had an opportunity then to deny being her father, as well as to deny it through his attorney at the subsequent hearing date prior to the fact-finding hearing. And I'd like to remind the court that fact-finding took place or proceeded at inquest. But the father then appeared personally again in court after inquest, but prior to the family court's issuance of its written order. And he could have again contested being the child's father on that date too, but he didn't. Instead, he identified himself on the record as the father and referred to the children without excluding any of the children. He referred to them collectively as my kids. So the family court erred in dismissing the petition on behalf of this one child, and we request that this court correct that error and find that ACS indeed proved Asela to be derivatively neglected. Thank you.
And does anyone else have any other questions? Okay, thank you very much, Ms. Bedell. We appreciate your coming in today.
Thank you.
Have a nice afternoon.
Thank you.
The next case for argument is Banks versus Bacopa. Okay, appellant.
Good afternoon, Your Honors. Lisa Viscardi of Sobel-Pevsner for the defendant appellant in this matter. I'm here today to ask the court to reverse the lower court's denial of our motion for summary judgment and find that the defendant appellant did not create any defective conditions.
Counsel, this is Judge Singh. You argue in your brief that there's no evidence that there are surveillance cameras in the supermarket, the store, the food bazaar, correct?
Correct. That issue
okay,
is not
okay, fair enough. But there is in the record the incident report. Now the incident report is at least it identifies a manager / claim personnel, Kang H. Back. Presumably he signed it, correct?
Correct.
Why wouldn't the statements in this incident report be considered an admission?
Well, the the issue of the videotape was not on appeal. This was never brought up or appealed.
Well, but it's raised in the papers. It's raised. It's precisely what we have to decide, because you raise it in your motion, saying that there's no evidence of it, and then you make arguments with respect to the incident report that it's hearsay. So my question to you: why isn't it an admission coming from the manager that there is a videotape, that there was produce on the floor, et cetera, et cetera?
It's not an admission. The incident report was made after the fact. He never admitted that there was a videotape. He admitted that he memorialized what he saw.
Wasn't there a box checked off on the incident report that said there is a videotape and it should be preserved?
Not that it was preserved, I believe. It was just checked off that there.
Well, it says, excuse me, it says the box is checked off is actually circled, yes. And it goes on to say in parentheses, if yes, please keep the video recorded of this incident.
That's correct. And the issue of spoliation was never brought up by the respondent in this matter in their opposition papers or any motions.
Counsel, what impact is there, though, that we still have an undecided spoliation motion? It's not a circumstance where the spoliation motion was either granted or denied, but it still exists out there, which means there still very well may be a determination of an adverse interest. It isn't just the existence of that spoliation motion and the fact that it wasn't denied enough of a basis to find an issue of fact based on the potential existence of the videotape.
Well, the videotape it has direct testimony by the plaintiff herself, which shows that there was no condition created. She never saw anything on the floor until after she fell. They're certainly on point with one of the cases in our appeal, the Bernard versus Waldbaum case, which was.
Counsel, that's not really addressing the question I asked, though, which is because the motion never got decided and there's still a possibility of an adverse inference, wouldn't that potential adverse inference be enough to raise an issue of fact if it was granted? And we don't know yet whether or not it's going to be granted. So separate and apart from anything else that was or was not said.
No, the question of fact would go to whether there was a creation of a condition and when the defendants had constructive or actual notice. The documentary evidence before the court shows that there was never any evidence pointing to the fact that the defendant created.
But counsel, we don't have the videotape. That's the problem. So if you put aside the videotape, you may be right, but there's still, if ultimately an adverse inference was granted, wouldn't that be enough to go to the jury? And isn't there still a possibility of that happening? So isn't that enough by itself to deny summary judgment?
No, I argue that it would not, Your Honor. I think the question is that there are no questions of fact to go before a jury, because that adverse inference would not go to whether there was actually a creation of a condition by.
Well, but I'm not sure that's correct. I haven't given the adverse inference charge in some years, but in fact, that's precisely what the charge says, doesn't it? That if the jury decides if there's evidence out there that they can consider that and making the determination, et cetera. Isn't that what it says?
Yes, you are correct.
So why, as my colleague is saying, why doesn't this case essentially hinge on that? If that charge is given, wouldn't there be a basis in the record for the jury to consider whether on the issue of notice?
Well, except for the fact that the issue of the adverse inference was never brought up on the appeal. It was reserved for the time of trial.
Right. But so what? I mean, it's still out there to be decided, right?
Yes.
And by the way, didn't the trial court say there were issues of credibility with respect to the making of the videotape?
Not as to the making of the videotape.
Or well, whether or not the videotape was in existence. Sorry.
No, the issue of credibility went to the fact they were talking about the defendant.
Well, but
manager.
Look at record page 5, and I guess in the short form portion of the order, the court does say issues of fact exist as to credibility, whether a video recorded the incident. Isn't that correct?
That's correct.
Okay, and one more question. Mr. Johnson says there are no cameras. The person who prepared the incident report is Mr. Bake. Did he submit an affidavit in this case saying, in fact, he was mistaken? There was no video in the store.
No, there is no affidavit.
Okay, thank you.
Okay, you'll have 2 minutes on rebuttal. We'll hear from Mr. Steinberg now. Thank you.
Thank you, Your Honors. That was going to be part of my argument, is to say, you know, there's a spoliation sanction still out
Well, but
there.
counsel, oh, sorry, go ahead. You want to ask?
I was going to ask why you did not appeal the lack of a determination on the adverse inference. Why was that not a course of appeal?
Well, I mean, we didn't think there was a sufficient basis to get a reversal when it is within the discretion of the trial or the judge determining the motion, whether or not to say this is really an issue for the trial judge, whether you get a negative inference charge.
Don't you need a determination as to the adverse inference to create an issue of fact vis-a-vis the video?
We don't need no, you don't, because it's still an issue for the trial judge to decide, and the judge herself determined that there was an issue as to whether there was a video or not. So she herself decided that in the motion. Now, it's up to the trial judge at the time of trial to determine whether we get the benefit of the negative inference charge, at which point the jury is free to determine whether they're going to say the video would have helped us had it been produced.
So, counsel, this is Judge Scarpula. Other than a negative inference that there would have been evidence, which the negative inference would be that there's a videotape and the videotape would show that the defendant had noticed, what other issue of fact have you raised?
Issues of fact are whether or not the defendants caused or created the condition, whether they had constructive notice.
Yeah, I know that those are the two things you have to prove. What do you have as evidence that either of one of those are actual issues of fact?
Well, before I even get to that, I would say the defendant first in a summary judgment motion, it's their duty to affirmatively establish the absence of any trial.
So let's assume that the defendant put in like logs. We check the store every hour. The guy checks the store. I mean, this is a pretty well policed supermarket. Again, I'm going to ask you, assuming that the defendant made their prima facie burden, other than your negative inference, what do you have to raise an issue of fact?
My client testified that the blueberries were all over the floor, scattered, stepped on, and appeared that they had been walked.
We have 100 cases that say that could have happened 30 seconds before she fell. What do you have to show that there was notice creation?
You have an admission on behalf of the store manager testifying that he saw employees stocking the produce department when he started his shift that day. There's no evidence submitted by the defendants in their affirmative proof, in their motion for summary judgment, to say, hey, there were customers walking all over the area that could have spilled the blueberries on the floor. All we know is there were only employees within the vicinity of the accident, aside from my client, in that area. That in and of itself raises an issue of fact as to whether those employees caused the condition or should have seen scattered, stepped in, walked all over blueberries during the course of the shift.
The fact that someone is unpacking produce, you're saying, raises an issue of fact? Wouldn't that be true in any case where a store had someone people unpacking produce?
Well,
is there anyone who said they saw the person unpacking the produce and fruit fell?
Well, to address that concern, I direct your attention to Rose versus .SC. This is a First Department case, 259 AD 2D 258. If there's proof that employees were within the vicinity of the condition that's observed to be dangerous, that's imputes constructive notice to the defendants. If there is evidence that only employees were in the area, that's what the Rose case stands for.
You're saying that as if there's an employee anywhere in the area at any point that day, that raises an issue of fact? That can't be right.
Well, Rose versus C, when there's proof that only employees were in the area, then that's enough to raise an issue of fact. That's what Rose says, where the person injured in that case was with a friend. The friend said, my friend went to the bathroom. During that time, I only observed staff walking back and forth in the area. So the court said that's sufficient to raise an issue of fact on constructive notice. This case is very similar because the manager admitted, it was the manager, not even my client, it was the manager that said, I saw employees stocking the produce department. When I got back from my shift, I don't remember what I saw. then there's no proof from a defendant, from any store employee.
Judge, this is Judge Skrupoulos again. Didn't he say like 6 minutes before the accident, he walked past and there was nothing on the floor?
No, that's incorrect. The defendants portray it like that. His shift started at 6 o'clock. He says he does 20-minute interval shifts, ends up back at the entrance. But he was asked, can you see the whole produce department when you return from your shift? He said, no, you can only see the entrance to the produce department. So it's unfair for them to characterize a 6-minute interval. It's actually more like a 26 to 30-minute interval, during which time only store employees were present, as far as the evidence is concerned.
Okay, does anyone have any further questions for the plaintiff? Okay, thank you, Mr. Steinberg. Ms. Viscardi, you have 2 minutes.
Just briefly, with regards to the time interval, the 26 versus 6 minutes, it's all speculation. It's the deposition testimony is clear that the manager testified. His inspection was completed 6 minutes prior to the incident. There's a litany of cases that show that a time limitation of anything less than 30 minutes is deemed insufficient to attribute a constructive notice to the defendant. The deposition testimony speaks for itself. There was a 6-minute time limit as to when he last inspected. The deposition testimony shows that the employees who were stocking the produce happened, much earlier during the day, at any time, way before the incident. So you can't attribute the employee's work to every incident that occurred that day. Thank you, Your Honors.
Okay, thank you both very much. Have a good afternoon. The next case for oral argument is People versus David A. We'll hear from the defendant.
Good afternoon, and may it please the court. My name is Amelia King-Musa, and I represent appellant David A. I'll be focusing on the interest of justice issues, asking this court to adjudicate David A. a youthful offender and reduce his sentence in the interest of justice. I want to begin by saying that the arguments today in no way aim to minimize the seriousness of the offense. This was a serious offense, but we simply want to provide the court with context. David A. was only 14 years old at the time of this offense. If it had not happened to occur near a school, David would necessarily be under the jurisdiction of the family court. Now, the record, even the indictment, make clear that this was a situation where men and older teenagers in a gang actively recruited and persuaded younger teenagers, including David A., to do their dirty work. Now, David A. fell under the influence of these men when he was only 13 years old, and this offense happened when he was 14. Now, David has been in custody since since late January 2019. And as soon as he arrived, he proactively reached out to mental health services. He was diagnosed with PTSD. He committed to seeing a psychiatrist and a social worker multiple times a week. He received his GED. He participated in over 10 completely optional programs, including learning how to code, write computer code. All of this was undertaken for his own betterment. He wanted to grow and change. Now, a lengthy period of incarceration is simply not necessary for David A. He has already been in custody for over 2 years, and that's an incredible amount of time for someone who's still under 20. We are simply asking the court today to allow David to re-enter the world without the stigma of a permanent record. This is not eliminating his punishment, but rather letting David, a teenager, get his first job, his first apartment, without the anchor of a permanent criminal record for things that happened when he was 14 years old. Now, I will just briefly turn to the appeal waiver arguments. The appeal waiver in this case is invalid. The court's explanation of what the appeal waiver covered was inaccurate and overbroad.
Was there a written waiver in this case? And didn't it cover those issues?
Yes, Your Honor, there was a written waiver in this case, but 2 quick points on the written waiver. First of all, a written waiver does not automatically cure deficiencies, particularly affirmative misadvice. The Court of Appeals just in December in People versus Bissono ruled that, when there is affirmative misadvice and the rights in an oral colloquy are mischaracterized, the existence of a written waiver does not automatically cure that, but it must be looked at in the totality of the circumstances, which brings me right to my second point about the written waiver, which is that the only time it is mentioned in the record is the judge turns to defense counsel, says, please explain this to your client, and then moves on. There's never any indication that David read the waiver, that it was explained to him, and that he understood the waiver. And this is particularly important, again, because at sentencing, he was only 17 years old. It cannot be assumed that he understood the intricacies of what was and was not covered by an appellate waiver. And if there are no further questions, then I will reserve the rest of my time for rebuttal. Thank you, Your Honor.
Okay. Thank you. And may we hear from the people, please?
Yes. Christopher Peterson for the Office of Darcel D. Clark. In this case, the court properly considered whether or not to adjudicate defendant youthful offender, and ultimately made the determination that it wasn't in the interest of justice to do so. And
how do you respond to the argument of your adversary that given his age at the time of the incident is something that we should take into consideration in using that interest of justice jurisdiction?
Well, certainly his age is relevant in determining whether or not to grant youthful offender status. He was young, and that was a factor that was considered by the court, certainly, in making the determination, as well as the various steps that he took towards rehabilitation. But the court also took into account the fact that the defendant committed a particularly heinous crime. He shot someone and actually hit the person and caused them an injury. So these were all factors that were before the court. And given the gravity of what he did, he received an appropriate sanction.
Mr. Peterson, was it true that this defendant was also involved in selling firearms in addition to actually shooting the gun that he had and seriously injuring the the victim?
So that is referenced by the court in the discussion of the youthful offender determination. However, it's not clear from the record on appeal what filing or statement by the people or even by defense that was relied upon. But yes, that was a factor that the court used in making its youthful offender determination. And it would be a relevant factor to determining this defendant's respect for the law or his reputation.
Counsel, were there any kind of affirmative misrepresentations by the court when the court was explaining the waiver to the defendant?
There were no affirmative misrepresentations. I mean, the court explained what it means to take an appeal. I mean, they explained explicitly.
Well, I think all the court says is statutory right to appeal. Isn't more needed than that?
Well, there was a statutory right to appeal that his rights were violated in some fashion is what.
Well, don't you generally also say there's certain appellate rights that aren't waived, et cetera, et cetera? I mean, all sort of the magic words that are in the written waiver, right?
Yeah, and here the court's explanation was shorter. There was, however, an exemplary written waiver, which the defendant signed and also was signed by his counsel. And the defendant orally relinquished his right to appeal in court with his counsel at his side.
Does anyone have any further questions for Mr. Peterson? Okay, thank you. And Mr. Peterson, obviously the people did agree to modify, to vacate the mandatory surcharge and crime victim assistance fee that we read in your brief. Correct?
That's correct, Your Honor. Otherwise, we ask for an affirmance.
Okay, thank you very much. Counsel, you have a minute or so.
Thank you. 2 points very quickly. First of all, as Your Honor pointed out, selling firearms was mentioned by the court as a reason for denying youthful offender status. That was not proven. There's only the one mention of that by the court. Nowhere else in the record is there any mention of that. Second of all, moving on to affirmative representations in the appeal waiver. There were affirmative misrepresentations in the oral colloquy. Specifically, the court told David that if he took the case to trial, he could appeal and, quote, make arguments based on the record that your rights were violated in some fashion, end quote, and that by waiving his right to appeal, he waived that right generally. Of course, you cannot waive some rights, and the court actually goes on and said that on an appeal, quote, you might argue that in a plea you were not advised of your rights, end quote. And the court characterizes that as an argument that David A. would be giving up by waiving his right to appeal. But if he was not advised of his rights, that would make his plea unknowing and involuntary, which is, of course, a right that you cannot waive. So in that way, the court did affirmatively misadvise David A. of his right, and that is something that could not be cured by a written waiver.
Okay. Anyone have any further questions? Okay, thank you very much for the arguments and the points. We'll take a look at it. Thank you.
Thank you.
The next case for oral argument is Darabont versus AMC Network.
Good afternoon, Your Honors. Can you hear and see me?
Kind of.
No.
See part of you.
Oh, that's
Sorry.
better. That's better. Now,
Okay,
now we got
thank
the
you.
full screen.
Okay. Good afternoon, everyone. Nice to see you all.
So the issues in this appeal have been somewhat narrowed since it started out, correct, Mr. Snyder?
Yes, Your Honor. There's a single issue for consideration on this appeal, and it's an important issue that comes before trial courts and this court all the time, and it is whether an implied covenant of good faith and fair dealing claim should be allowed to proceed alongside a breach of contract claim. And it's an important issue, of course, because a bedrock principle of New York law is that, and as some of Your Honors on this bench have taught me, for better or worse in different cases, a contract is to be enforced in terms of and in accordance with the mutual intent of the parties based on the express terms in the agreement. And this court has held time and again that you cannot use an implied covenant of good faith and fair dealing to impose extra contractual obligations on the parties, or stated another way, shouldn't be used to rewrite a contract years after the fact. And the record
Counsel,
in this case—
before getting to that issue, the precise theory that plaintiff is asserting now, was that in the complaint originally?
No. They first said that, and this would have been an implied covenant claim, actually, because what they said is we breached the agreement because we accounted to them incorrectly. We basically ripped them off under the contract by not accounting to them in 14 different ways that are very technical, involving how you pay profit participants under a profit participation agreement. So that's sort of your classic accounting breach of contract claim. They also alleged in the complaint as an implied covenant theory, which we would not have moved to dismiss necessarily, that we frustrated their audit, that they tried to audit us and we were bad actors and stiff-armed them and wouldn't let them audit us and dragged our feet and did all sorts of things. They abandoned that theory because they acknowledged in their opposition brief on summary judgment that they had no damages for that claim. So what they did is they said in their opposition brief, we have a new implied covenant theory, and it's that the way you breached this contract was really bad. They use words like bad faith. They say arbitrary. They say not custom and practice. But of course, that's just a repackaged breach of contract claim. And so we moved for summary judgment, and the trial court committed error by not dismissing the implied covenant of good faith and fair dealing claim, because that claim is based on the exact same operative facts as the breach of contract claim. That is, these 14 accounting issues under the contract. And,
Are you
and
also
so
arguing, though, that it's untimely? I understand the argument you initially made, which you just seem to have repeated, which is that substantively there is no claim for implied breach. But are you also making the separate argument that it's untimely because it was only raised for the first time?
yes, yes,
In opposition to the summary judgment as a
we
separate.
are.
Okay.
Yes, we are. And the reason that's not just a technical gotcha point is we really were prejudiced by that because we conducted discovery for years, in fact, a couple of years, and we were just asking questions about the frustration of the audit. We didn't go into custom and practice and on these claims to the extent and in the way we would have if we understood their claim to be one that said, not only did you breach the contract in 14 different ways when you accounted to us, but you acted arbitrarily, in bad faith, and inconsistent with industry custom. So basically, this is just a second bite of the apple. They want to argue to the jury, we breached the contract. If the jury says, no, you didn't, because these sophisticated parties negotiated very clear accounting terms and AMC complied with them, they then want to say, well, even if they complied with them, it was unfair, it was arbitrary, and it wasn't what the custom in the industry required. And of course, custom in industry is irrelevant, whereas here, sophisticated parties, and here the most sophisticated parties imaginable, we have CAA as the plaintiff, the most powerful talent agency on the planet, negotiated this contract. And so you have the two sophisticated parties negotiating very clear accounting terms. We account under those terms. They sue us for breach of accounting, and that's going to go to a jury, and the jury is going to count the beans 14 times and figure out if we did it right or wrong. What they can't do is now say, even if you think they counted the beans the right way 14 times, you should hold them liable because we don't think they did it in a way that's consistent with the custom industry of the custom and practice of the industry. So really, there are three independent reasons the court should dismiss the implied covenant claim. One is it's completely duplicative of the breach of contract claim, and we cite many First Department cases. Mill Financial is the most cited one, which says where you have conduct alleged in two causes of action that arise from the same operative facts. By the way, exact same damages too. There's no separate theory of damages. That's enough to dismiss the implied covenant. The second one is you can't rewrite terms of a contract years later through an implied covenant. And the third, as we just discussed, is the untimeliness. And unless the court has any other questions, I'll reserve.
You have a minute for rebuttal. Okay, thank you. Perfect time. May I hear from the respondent, please, Mr. Bernstein?
Yes. Good afternoon. My name is Jerry Bernstein of Blank Rome. I represent the plaintiff's respondents. I'd like to address each of Mr. Snyder's points. So to begin with reference to whether or not the implied covenant claim is duplicative of the breach of contract claim, with respect, the court needs to focus on the particular facts here. So there was an underlying contract that was executed by the plaintiff, Mr. Darabont, in 2010, and then something called the Season 2 Amendment. These audit claims, so-called, that are at issue here, arise out of something called the MAGR or MAGR definition, which was not provided to the plaintiff until after he had signed the contract. And it's in that document, the MAGR definition, that the defendants set forth their treatment of these audit issues that the plaintiff is complaining about. So it couldn't possibly be duplicative of the breach of contract claim. Second, this argument that the defendants are making here has been ruled on 3 times. First by Justice Branston in the consolidated related case involving the so-called imputed license fee.
Counsel,
Second by
Judge Singh. Counsel, when did you first raise your theory that the defendant was acting in bad faith, and that gives you a basis for an implied covenant claim? Was it in your complaint, or is your adversary correct that it was raised in opposition to summary judgment?
It's in our complaint, and I respectfully would draw the court's attention to A96 in the appendix, which is paragraph 36 of the complaint, which, well, first of all, in paragraph 34, we incorporate by reference all the allegations, the prior allegations in paragraphs 1 through 33 of the complaint. And then in paragraph 36, we state, quote, AMC has breached the covenant of good faith and fair dealing implied in the Darabont agreement by engaging in bad faith conduct intended to frustrate plaintiff's rights.
Rights, though, in that paragraph?
I'm sorry?
When you were talking about the covenant of good faith and fair dealing, weren't you referring to the audit rights in the complaint?
We gave as an example, it says, among other things, those are the words in the complaint, that
So, Counsel,
AMC.
Judge Scarpula, may I interrupt you for just 1 second?
Sure, of course.
And ask you, did you ever raise the issue of custom and usage under the MAGR in the complaint? Did you ever amend the complaint to add that after you got the document? Is there any paragraph in the complaint that talks about custom and usage with respect to that calculation, even after you got it?
I'm sorry, Judge, you cut out a little bit. I think I got the gist of what you're saying. The answer is that there is no issue, and as Justice Cohn found,
I'm just asking about allegations, not issues. Is there an allegation in the complaint about custom and usage being implied in that calculation?
Well, the answer is no, Your Honor, but it doesn't need to be. Custom and usage is the whole essence of these audit claims. So in this industry, Your Honor, there are audits routinely
but
done.
Counsel, I'm sorry to interrupt. But doesn't that prejudice the defendant? You've gone through discovery, correct, at this point?
Yes.
And then in an opposition to summary judgment, you raise custom and usage for the first time. Hasn't the defendant now been foreclosed to get discovery on the issue, which should have been provided or should have been given notice of years ago?
Absolutely not, Your Honor. For one thing, this prejudice argument is so unimportant to the defendants that they didn't even raise it in their opening brief. It didn't even show up until their reply. So this was clearly not something that was very much on their minds.
Oh, until your opposition. So how could they raise it to the reply? It was only in your opposition that you talked about custom and usage. So how could they have raised it before?
Well, but their point, no, with respect, Your Honor, their argument is now that they were prejudiced. We didn't have an opportunity to take discovery and so on. They didn't. That was an argument that was alive to them from the very beginning and would have been, one would have thought, featured in their opening brief, but it wasn't. It didn't show up.
But don't they have to be on notice? Don't they have to be on notice before they can respond? I think that's what my colleague is saying, right?
Well, they're certainly on notice of the existence of the implied covenant claim if they believe that they were, and that it applied to all these so-called audit claims. That's what the whole appeal was about. There were two decisions by Justice Cohn, two of them, in two separate motions for summary judgment. Both of them he denied the motion for summary judgment and found that there was no issue having to do with notice. And in fact, it was disposed of by Justice Cohn in a footnote in his decision, footnote 6, where he writes, AMC contends that plaintiff's implied covenant claim is limited to allegations regarding the audit itself. The court does not read the claim that narrowly. And there is no prejudice. They've had ample discovery, and it's just simply not an issue, Your Honor. And they recognize it because they didn't raise it. I'm sorry?
Let me ask you this. Was there any discovery about custom and usage with respect to that number? Was there any deposition testimony as to it?
Absolutely. There was expert deposition testimony. There was an expert report that was provided by the defendants. That expert was cross-examined. They even moved to exclude the expert.
Fact discovery, right? I mean, your expert is after fact discovery is closed. So was there any fact discovery about anybody talking about, we all assume that custom and usage would be a part of that calculation?
Well, of course, there was fact discovery about the nature of these audit claims.
No, I'm
And-
asking you specifically. Your claim is that there was bad faith in not incorporating custom and usage in that number. And I'm asking you, because there's nothing about that in the complaint. I read the complaint, so did you, so did everyone. There's nothing about it in any of your discovery responses. So now I'm asking you, is there anything, any fact testimony about that claim?
Your Honor, I cannot sit here today and tell you, having gone through hundreds and thousands of pages of depositions, whether or not that was specifically addressed. I can't answer that question, and I wouldn't presume to do that. And I wasn't prepared for that question, frankly, and I didn't read all the depositions in advance of the argument. But I go back to this point, Justice Scarpullo. In an audit case such as this one, it is standard industry practice. Every case such as this one involves an audit done after the
I'm sorry,
show.
counsel, let me stop you there. So
Sure.
this essentially is an audit case, right?
This part of it is an audit case,
either
yeah.
you're correct in the numbers or they're correct? So
Correct.
this term that you're trying to impose, isn't this sort of an additional term that wasn't contracted to by the parties? So it seems to me that you shouldn't be able to get a second bite, in essence, at the apple. Either you're correct with your numbers or the defendant is. And if the defendant's correct, that's the end of the story, no?
No, with respect, no. It's not about simply doing arithmetic. It's about deciding and determining whether or not certain factors are taken into account. What's the meaning of a distributor, for example? And I think it's noteworthy in this regard that the appellants do not once address a single one of the actual audit claims. When you look at the audit claims, they're not about does 2 and 2 equal 4. It's about the definition of something like a distributor, for example. And those are things, those concepts are governed by industry custom and practice. And everybody understands that when they enter into a contract in this television industry, that there are certain ground rules and certain expectations that somebody like Mr. Darabont would reasonably expect. And that entitles him to pursue the implied covenant claim because when those industry customs and practices, which he reasonably expected, and that's the standard in an implied covenant claim, are breached by the appellant in a document that they imposed upon the appellant only after the fact, after he had signed the contract, how else is he supposed to pursue his claim? Sometimes it's a breach of a particular aspect of the contract, but other times it's not.
Counsel, this is Judge Scarpullo. Is there anything in that? Oh, I'm sorry, Judge Kern, did you want to speak?
Is that exactly the deal you negotiated, that they get to define the term? When he entered into that contract, he knew that he was giving them basically unfettered discretion to define these terms subject to this express provisions in the contract. And now, isn't this really just an attempt to renegotiate exactly what was negotiated between the parties?
No, because with respect, in situations such as this one, not every single point in the so-called MAGAR definition is covered by the contract necessarily, because the parties have expectations in this industry that when you enter into certain types of arrangements with advertisers and so on, that it's going to be handled a certain way. And when it's not handled that way, as the appellants did, I'm sorry, I didn't mean to interrupt.
Wait,
I ask the question, which is, I'm going to forget my question. Didn't you have the right, if that's what he wanted, couldn't he have said that this term will be defined per the customs and industry of the customs and standards of the industry? And if that's what you wanted to negotiate for, you could have negotiated for that, but that's not what the contract says, is it?
Well, it's standard. It's an underlying understanding of anybody in Mr. Darabont's position who enters into a contract like this, that the studio or / network, here they were the same, are going to act fairly and not arbitrarily or capriciously, which is what they did allegedly here. That's our claim. And you don't have to write that in. Everybody understands that when they enter into a contract that they're going to be dealing with somebody in good faith. And what happened here was AMC didn't do that in the way they calculated certain aspects of these audit claims. And that was not something that needed to be spelled out in black and white. Everybody understood it. That's why it's an implied covenant. That's the essence of it.
But counsel, just looking at it from a broad perspective, essentially what you're arguing is in every contract case, based on your arguments today, there's always a implied covenant claim. And that's not what our law holds, I don't think.
Well, I don't want to speak for every contract.
Well, but it's a very broad argument you're making, or at least the principle that you're espousing.
Well, in every contract there is read into it an implied covenant of good faith and fair dealing, and that was what was breached in this particular case.
But the counsel, that you will perform the contract in good faith. You're not arguing that. You're arguing that he didn't import the customs of the industry, which is not that he didn't, that the defendant, I should say, didn't comply with the contract. It's that they didn't do something that you thought they should do. That's a totally different argument.
It's not, with respect, it's not about what we thought they should do. It's what one would reasonably expect.
Then why isn't it in the contract, right?
Because there's certain things you just don't have to say. Like if you're renting a building, you don't have to put in the contract, it's going to have a roof on it.
Well,
because it obviously is going to have a roof on it.
Well,
I mean, this is something that's so basic in this industry that when AMC didn't meet those requirements of what everyone would expect, that's a breach of the implied covenant, because that's what was reasonable for Mr. Darabont to expect as somebody in his position, and they didn't do that.
Okay, we've given you some extra time, Mr. Bernstein, but thank you for answering our questions. Mr. Snyder, you have a moment of rebuttal.
60 seconds. Thank you.
Okay.
I just want to say very quickly, as your honors noted, if you look at the complaint, it wasn't in the complaint. We were blindsided by this new theory. Had we been on notice to a number of your honors' questions, we would have approached discovery differently. For example, we would have probed further with the fact witnesses, as we did not do, why they thought not only we didn't comply with the contract by its written terms, but what about the contract was inconsistent with the way things are done in the industry. For example, their big claim, one of them is product integration. That's where you have a Pepsi can in a TV show and Pepsi pays you for it. And they say that revenue should go to them, or a piece of it should. We say it shouldn't. So we talked about the contract, and we did not take fulsome discovery about the custom and industry, nor did we explore that with their fact witnesses to the same extent we would have. But more fundamentally, as your honor said, and then I have another 15 or 20 seconds, this is a precise contract with 14 different audit claims. It's very technical stuff. And how we account is governed by agreement, negotiated by sophisticated parties, not by some free-floating idea of fairness and custom. That's what they want to smuggle into this case. It doesn't belong here because, as I think Justice Singh said, this is not the jurisprudence in this court. The jurisprudence is duplicative. Implied covenant claims cannot proceed alongside breach of contract claims, and that's exactly what they want to do here. So we respectfully submit that the implied covenant claim should be dismissed, and the plaintiff should be go to trial on these 14 claims and prove them or not, but not have a second bite with a make it up as you go along custom and practice argument. Thank you, and have a nice afternoon.
Okay. Thank you both very much. Appreciate the arguments. Our next case is Century City Mall versus Waxman. The appellant, you have 6 minutes.
May it please the court, my name is Tom Lambert from Lambert and Shackman. I represent the appellant Jonathan Waxman in this case. The error that we believe the court made below was in considering this guarantee to be an absolute guarantee, whereas it is not. It's set forth at 115 in the record. And the guarantee only comes into play, as it says in the guarantee, if the tenant shall default. So unless there's a proven default by the tenant, there is no guarantee obligation at all. I couldn't hear Justice.
Well, because I was muted. Mr. Lambert, I'm sorry. Is it possible for that determination to be made just looking at the guarantee, or does the court have to look at the underlying facts whether or not there's an underlying default, et cetera.
Yes, the court, well, based on the literal terms of the guarantee, the dictates, the rule set forth in the guarantee, the court is required to look at whether or not there's a tenant default and the underlying facts, which would determine whether there's a tenant default or not.
Well, the judge in the motion part relied upon a case, Royal Equities Operating, and it seems to me that there may be a distinction because here the defendant Waxman did not actually waive all the defenses, and that would distinguish that to some extent from this case that the judge relied on.
Well, I think yes, Your Honor, I think what distinguishes the Royal case, which is a very good, solid case, is that in the Royal case, there was an absolute guarantee. In other words, in the Royal case, the court finds that the tenant must establish prima facie that there was a failure to pay the rent.
Right.
But they also determined that there was an absolute guarantee in that case. And so wasn't necessary to get into whether there was a defense of the tenant to any claim of default. In our case, it's just the opposite. The guarantee is not an absolute guarantee, and it is necessary for the plaintiff to prove that the tenant defaulted. And if there's a defense to the claim that the tenant defaulted in the payment of rent, that defense must be considered because that's what the guarantee says. In the Royal case, it was different. That's what distinguishes the Royal case. Judge, I asked myself, we all asked ourselves, well, how is it that the judge, what is maybe what the judge was thinking here? And I think maybe the judge was doing some speculating. The judge said, well, maybe he got $1 million worth of publicity in LA Times. He knows the business. He says, you know what, I'll do a guarantee. And then the judge recognizes, in his opinion, you have a very, very good argument, Mr. Lambert, that there was a default by the landlord under the lease. And there's been an undisputed repudiation by the landlord. The facts which constitute a repudiation are not disputed. The facts which show that the rent commencement date never arrived, are not disputed. And the judge recognizes all that says, but he said, that's not what's before me. What's before me is the guarantee, as if the guarantee was somehow a meta document that bore no relationship to whether there was an underlying default by the tenant. And that's not correct. And then the judge goes on to say, yeah, potentially fine. And the guarantor doesn't even seem shaken by it because he's in the restaurant business. He doesn't want bad publicity. I don't want to speculate. Well, that's what the judge was doing, a lot of speculation here. And I wonder whether the judge was feeling and imagining that this landlord.
The judge is feeling. I'm sorry. I've never heard an argument like this. We don't care what the judge was feeling. You just have to argue.
Well, the judge
was right. The judge got the law right. The judge got the law wrong. We really don't care what the judge is feeling.
Yes, Your Honor. I agree. Your Honor, Napoleon said that imagination rules the world. And in the court, it's not imagination that rules, it's the law. And I'm concerned that this judge may have been inclined to believe that the landlord was somehow tricked here, that he was dealing with this Jonathan Waxman, the cook, thinking he's the tenant, and then he chose.
So Lambert, aren't you just engaging in speculation?
Right. Whether the judge got right or the judge got wrong. That's it.
That's right. There's no allegation here that the landlord was tricked, misunderstood anything. And one other thing about speculation, Judge, on page 26 of the respondent's brief, they say this is the argument about the moving affidavit not being sworn. It says this argument was not briefed by the parties in the trial court because Waxman raised it for the first time at oral argument on the motion. Well, that sounds like it's a little bit of a dirty trick. But we can only say what's in the record here. And what's not said here is whether or not opposing counsel was notified a week in advance that this would be argued and that this was a mistake we found in the papers and that we were going to argue. There's nothing here that suggests that they didn't know very well when they walked into the oral argument that this was going to be raised. And yet they didn't address it even when it was raised at the oral argument. That's a real.
Okay, well, you've had your time. Does anyone else have a question at the moment? Okay, you'll have 2 minutes in rebuttal. Okay, can we hear from Mr. Kessler, please?
Good afternoon, Your Honors. John Kessler from Blank Rome on behalf of Plaintiff Respondent Century City Mall, LLC. So let's take a step back from whether or not there was a waiver of defenses in the guarantee. That's just one basis for denying this appeal.
Well, but if there's no waiver, of defenses, then why can't the tenant raise the defense that the premises were never delivered? And then how can we decide on a 3213 motion that underlying issue?
Well, Your Honor, if he's going to object and say the rental commencement date was never triggered because they didn't deliver the premises in delivery condition, you can't just put that in affidavit and say that. How about some proof? For example,
counsel, once you're getting into proof, you lost. This is a motion for summary judgment in lieu of complaint. So for you to win, it's not about proof. You have to be able to show that on the face of the document, you win. And I have to tell you, having seen thousands of guarantees in my life in landlord-tenant situations, this is actually the first one I've seen that clearly is not unconditional. Because normally there is language that's unconditional, all defenses are waived, and the landlord usually can get summary judgment in these guarantees. But this one is the exact opposite of that. So for you to win, you have to show that something about this guarantee gives you the unconditional right to get rent without any defenses. And that doesn't seem to be what this guarantee says.
Your Honor, whether a guarantee is unconditional relates to whether or not you can proceed. It's whether it's a guarantee of for payment or a guarantee of collection. In this case, it's clearly a guarantee of payment because we're allowed to proceed directly against the guarantor upon establishing that there was a default on the underlying obligation. But that's true with every type of guarantee. It's always
respectfully, that's not correct. As my colleague was saying, you can look from the face of the documents and make that determination, and that's what's lacking here.
So, Your Honor, that would require then every guarantee to have a waiver of defenses to bring
in New York.
It does.
That's correct.
Well, Your Honor, hang on for 1 second. In I Building Inc. Versus Chong 137 AD 3rd 478 First Department 2016, the guarantee did not have a waiver of defenses, yet this court still held that when a guarantor is sued alone or sued on a guarantee, as is the case here, he or she cannot raise a claim or defense which is personal to the principal debtor, such as breach of the principal contract, unless it extends to failure of consideration for the principal contract.
Isn't that what we're arguing here is failure of consideration?
Right.
If you never delivered the premises, isn't that a failure of consideration?
No, Your Honor.
Because rent wouldn't commence until the date you delivered the premises.
Your Honor, there's no dispute that the tenant had access to the premises, and again, for him to just say they didn't satisfy some obligation, they're arguing a failure of a condition precedent. That's essentially, they're saying that we started billing them too soon, and that they're not obligated to pay. But that's a defense that's unique and personal to the tenant. That's not an argument about failure of consideration. They're saying we didn't satisfy a certain condition about the construction, the way it was built, and that's why they say they have no obligation to pay. And to the extent,
Okay, go ahead. Do you have anything else?
Well, to the extent it relates to this affidavit, again, he sent an email the week before oral argument, which was obviously after the brief was fully submitted. So there was no way to address it. And we did fully address it both at oral argument and in response to this appeal. And the case law that we've cited in our brief is nearly identical as it is, to the situation in this case, where the notary merely signed an acknowledgement rather than a jurat. But in this case, we also have a certificate of conformity from a California attorney.
Yeah, I mean, I just want to go back to the point that I don't see how you can claim that under the record in this case that there is not at least some evidence showing that the plaintiff may have delivered possession to the wrong tenant, not the entity they were supposed to, all which goes to a failure of consideration and problem with defendant's obligation to even commence paying rent, and how this can be decided based on what we have before us, just on, in our 3213 motion. I mean, there's so many facts out here.
Your Honor, they did a good job of muddying the record, but this is really a simple case about, the rental commencement date. There's no issue about whether we delivered the property to the correct tenant. They have an argument that comes in later saying we repudiated the lease. But again, if it's relating to, if repudiation is the argument, that is a form of breach of contract, and the tenant agreed that it was obligated to pay rent regardless of any breach by the landlord. So that means it also says there can be no offset or deduction. So their obligation to pay rent is unconditional. And if the tenant can't make an argument for offset based on a breach of contract, then nor can the guarantor. So, Your Honor, I don't think it's
counsel. The claim here is you didn't deliver possession. That's the claim. They're not looking for a set off. They're saying the rent commencement never started. That's the argument.
Your Honor, there's no dispute about delivery of possession. The dispute is whether the rental commencement date was triggered, and that is because they're saying you delivered the premises, but it wasn't in delivery condition.
Can that determination be made on the face of the guarantee?
Well,
don't we have to look at the underlying facts, and for that reason, 3213 relief is not appropriate in this case?
Your Honor, there's still a burden shifting, like any motion for summary judgment, there's still a burden shift where we made our prima facie showing that we delivered the premises and the rent commenced. You can't just come with an affidavit saying, yeah, that the rental commencement date was never triggered. So we have to go to trial for that. There really needs to be more. For example, in a recent case in the Second Department, the issue was whether the rental commencement date was triggered. And in that case, the premises needed to be delivered in delivery condition, which was defined as vacant, broom cleaned, and free of the prior tenant's personal property. Rather than simply relying on an affidavit stating that the delivery conditions were not satisfied, which is what Mr. Waxman did here, the tenant submitted contemporaneous photographs showing that the premises were filled with the prior tenant's personal property and enough trash to fill 3 dumpster containers. So basically, that would be sufficient to create a genuine issue of fact.
Okay, I think we got your argument. Mr. Lambert, you have 2 minutes in rebuttal, okay?
Thank you. Just want to say that in the Royal case, it's clear from the Royal case, as quoting the Royal case, as guarantors who expressly waived all rights and remedies generally afforded under the law, defendant's liability can be greater than that of the obligor tenant. That's a different guarantee than the one we have in this case, which is an unusual guarantee, where I think even opposing counsel now just acknowledged that they must prove default by the tenant in the performance of his obligations. There was no default in the payment of rent here because landlord repudiated the lease.
How do you respond to your adversary that a conclusory affidavit is insufficient to show that you have to put in more proof?
Well, I'm sorry, I don't understand the question.
You don't understand the question?
No, they didn't prove a prima facie case, but in a way.
Okay, so that's your position. They didn't prove a prima facie case.
Procedure. Look, we don't have time. I don't have time, but they didn't present the prima facie case. It wasn't a sworn affidavit. But there are 2 defenses that the tenant has. One is the landlord repudiated the contract. That means there's no rent due. The landlord was dealing with another entity, approving the plans of another entity. And that completely repudiates the lease. Then the rent commencement date, based on the definitions under the lease, never set in. Because the landlord's work was not substantially complete, that's alleged and is not denied. But the tenant can be in possession, and nevertheless the rent doesn't start. That's clear in the lease. The data sheet, item number 2, record page 34, the lease section 1.02C at record page 40, the lease 1.02B in page 40, and the lease section 5.01B at 49. We set this forth in our brief, but so that that can be looked at, it can be readily seen that delivering possession does not start the rent from running. The landlord must complete its work, and there was no dispute that the landlord, on this record, that the landlord simply did not do that.
Okay, thank you very much. Thank you both very much. Have a nice afternoon.
Thank you.
For coming. Okay, our next case is Carlyle Commodity Management. We'll hear from the appellant first.
Yes, may it please the court. Good afternoon. My name is David Yohai of Waugatcho and Manges on behalf of the plaintiff appellants Carlyle's Commodity Management and the other Carlyle entities. This is an appeal from the trial court's improper, in our view, granting of summary judgment on a record compiled over 2 years of litigation that frankly is replete with fact issues. Indeed, despite finding that the agreements at issue actually supported Carlyle's position, the trial court nonetheless, based upon conflicting factual evidence, found that there was essentially a course of conduct that allowed Samir, Morocco's only oil refinery, to take oil.
Counselor, this is Judge Singh. I'd like you to sort of focus on 2 different time periods. One is before the freezing of the bank accounts. And wouldn't it be fair to say that at that time, before the bank accounts were frozen, that there was a custom and practice for plaintiff to acquiesce to Samir's use of the crude?
No, and that was a chief confusion, I think, of Judge Sherwood. In fact, before there was a freezing of the bank accounts, if there was any taking of the oil without payment, there was objection. And this is in the record.
I know after there was an objection by email, but before really their email saying you cannot use our crude for any purpose prior to that, or were there demands of making payments, et cetera, and then Samir would make payments?
Absolutely, there was documents in April and May where explicitly Carlyle said you cannot take this oil without our consent, and they objected. And it was immediately rectified. In addition, the testimony of Mr. Olivo, did you ever give Samir permission to consume the product without paying for it? No, that's at the record. But
didn't Mr. Olivo also state in an affidavit that Carlyle understood that a discrepancy could arise from time to time between the volume reflected in the inventory reports and the amounts that Carlyle owned? Samir was, after all, a working refinery. So it seemed that there was an understanding that, it would be tough to keep the records because this is a working refinery and it'd be hard to keep an exact count on what's at the refinery, what's being used, what the status of all that oil is at any given moment.
So there, Your Honor, what they're referring to there, and I believe that was Mr. Suvagaya's testimony, but that had to do with a weekly inventory report and whether the report at the beginning of the week or the end of the week would be exactly the same in terms of the timing. That was not a custom and practice. And given the testimony of Mr. Olivo and Mr. Zuick that there was no consent to processing without payment, I don't understand how you can grant summary judgment on this record. In particular, the agreements also stated clearly that we own the oil and that until they paid us, title always remained with us. That is a critical distinction here that takes it out of any of the cases that the defendants cite. Title remained with us until we were paid for it. And so therefore there could be no taking of the oil without payment, without paying for it. And also it required written consent in the contract. There was no written consent to this, clearly.
But the question is whether there's acquiescence. I mean, because it seems to me what was happening is oil, Samir was selling its oil, you're making demands for payment, payments were being made, but after August, the circumstances changed. So why don't you address after August what happened?
Okay. After August, it was similar in that we also objected in September to the taking of the oil without payment. And in both situations, you have to remember the following. As the victim of here, either a theft or a taking without consent, we were in the position of them having taken it, and then we're the victim at that point. So you can't say that there was an acquiescence or a course of conduct when we objected at every turn. But the key point here is these are all factual questions. How can you resolve this on summary judgment given the testimony of the key witnesses here? That's the core issue. In addition to that, if you look at the policies themselves, these are all risk policies, which means all risk of physical loss from whatever cause arising. Justice Sherwood imposed this other hurdle of proving stealing based upon some definition that he thought that one of the definitions in the dictionary required about stealing dishonestly or with malintent. That's not a requirement under the policy. In fact, if you look at the Fabrique case, which is exactly on point, defendants say, well, on a first read, the facts are very similar. Frankly, on a first read, a second read, and a fifth read, the facts are almost identical to this case. In Fabrique, what happened was the producer of the product stored product at a second party's warehouse. And then that second party was selling the product because it found itself in dire financial circumstances, was selling the product to customers that the first party didn't authorize at lower prices. And they made the same argument in Fabrique that defendants are making here. They said, well, that's just a breach of contract and you consented to it. No, there was no consent. Title was reserved to the first party. And just because the second party starts selling this stuff.
But yet counsel, and again, I mean, it seems to me that you're blurring activity before August and after August. Before August, when this would occur, you'd make a demand for payment and payment would be immediately made. Isn't it a fact that after August, after you send an email saying no more, you can't do it, that the circumstances changed?
I don't believe so, because even before August, we weren't saying, oh, pay me later. We were saying you can't do this without our consent.
Well, after August, they can't pay you anymore because the bank accounts are frozen. It's over, right?
Well, that's of course true also, but that doesn't make it any less of a taking without our consent. In other words, that's the whole point.
Before August, though, didn't it become, in effect, a course of conduct that this was how business was done between the two parties? And you're saying you didn't acquiesce, but you kept going with that setup, knowing that this had occurred on numerous occasions and kept them demanding payment and kept going forward with that business arrangement.
Before August, there was only one incident before August where they took product out of the tank. We immediately objected and they rectified it within a matter of 2 or 3 days. That can't be a course of conduct. But more importantly, when they take it without our consent and we object, how can that be a course of conduct? We never extended credit. This wasn't a credit arrangement where they could just pay us anytime they felt like it. It also doesn't make any logical sense. This was our oil and the contract said they had to pay us. But once they take it out of the tanks, what choice do we have? We're in this situation. And that's the key fact here. And again, remember, we always had title. So even, Your Honor, if you believe what you're saying, that somehow we authorized something, we still had title to the oil. They had an obligation to return it to us, and it's an insurable event. That's what Judge Shore, quite frankly, got confused about in terms of this timing. We objected at the beginning. And again, let me give you all the record sites. R1038, R1064. There was no consent. And the answers are unequivocal. Did you ever consent to processing without payment? No. How on that record can you grant summary judgment, which is what we're talking about here? Okay, that's the problem with this case. Consider the fact that the case, when it was argued, it was in May at the height of the pandemic with a trial date looming, okay? With all due respect to Judge Sherwood, what happened here was he seized upon a definition of stealing that supported a view that he wanted to take here to get rid of this case. That is not what happened here, okay? The definition of stealing under the dictionary definition, there are several definitions. One is just a taking, okay? A taking without our consent. And that's what happened here. We don't have to prove any more than that.
Counsel, again, and I hate to harp on this, but going back to pre-August, there was a taking, okay? They rectified it by giving you payments. And so isn't that, and this, it wasn't just one time, there were a series of this. Doesn't that, as my colleague suggests, is a course of conduct that you acquiesce to this kind of business transaction?
I don't understand how you can acquiesce to that unless it's over a much longer period of time. We're talking about a matter of a few weeks
This was what,
here.
just a few months, Mr.
Exactly. Less than that, in fact, in terms of the time frame. Between August and September, I mean, we're only talking about a matter of a few weeks. And in addition to that, consider the fact this is in Morocco where they have tanks. To even check what is going on here is an enormous undertaking given the back and forth and international situation with tanks.
It's not such a long flight. I've been there, but in any event.
Well,
all right, Mr.
okay.
Yohai, I think we got the it's like going to California. I think we've got your argument. Let's hear from Mr. Woods, and then you'll have a few minutes for rebuttal, okay?
Thank you, Your Honor.
Thank you very much. Mr.
Thank
Woods?
you, Your Honor. Thank you, Your Honor. First, the insurance policy at issue here covers physical loss or damage to the oil, damage and physical loss in the traditional sense, right? Ship that's being carried on sinks, or there's an explosion.
Well, so you're saying physical loss could not be that you take it and it wasn't yours, and so they lost something that belonged to them that you hadn't paid for? Is that not loss?
Well, I'm just saying there was no physical loss of damage, and that's why the plaintiff in this case has to shift and say there was a theft. That's the loss.
Well, I don't think that's no. I disagree. What counsel is saying is that there was a taking without consent of their property. They don't have to show theft in the classic sense, right?
Right, but it's frankly beyond disingenuous for Carlyle to come into this court and say that they did not know that Samir was refining the oil from the moment that it arrived.
Okay. Again, I'm sorry, counsel. Now, you're talking about the pre-August period or post-August period? So I'd like
pre-August period, Your Honor. When there was a long period of negotiation, and then when the course of business started in February with the first deliveries, and deliveries went through July. There was a series of shipments, several per month, 3, 4 per month, and those transactions worked fine. But it is not arguable by Carlyle that they did not know that the oil was being refined from the moment it arrived at Morocco. And the reason for that is that this refinery had been in business for decades. It was Morocco's only refinery. It was a busy refinery, and it had a voracious appetite for the feedstock or the raw materials, which had then turned into gasoline and other products that were sold into the Moroccan market, jet fuel, which gave Samir the money to repay Carlyle for those shipments that Carlyle elected to advance the money for Samir. They had 90 days and later 120 days to repay
what you're saying is that obviously they must have known that you were refining it, because how else would you be able to sell it and get money to pay them for the raw materials in the first place?
Exactly. And Mr. Yohai a moment ago said that it was not logical for this to operate otherwise. I would take the exact opposite approach. It would not be logical in any way, shape, or form for Samir to take delivery of what amounted to hundreds of millions of dollars of oil and then be required to sit on that oil for 90 days, later 120 days, repay Carlyle, and then use it. What would be the commercial reason for that? Nothing. No commercial reason. Samir didn't have the money to pay for the shipments when they first arrived, and they had to take those shipments in order to generate the products that they could then sell for the money that they would use to repay.
Okay, so that's before August. But what about after Samir's bank accounts were frozen in August? Samir continued to engage in this practice, and in this instance, bank accounts were frozen. There's no money going out to Carlyle.
But by that,
is there a distinction to be made in terms of activities before August and post August, especially where plaintiff sends an email saying, stop doing this?
That is such an exercise of closing the barn door after the horse has bolted. The refinery had run into financial difficulties. It was not receiving shipments. There were ships sitting out there that were not able to deliver because they weren't being given cash on the barrelhead or guarantees that they would be paid. And they were not willing to take the credit risk, which, by the way, Carlyle was up until the time it stopped doing business with Samir. They were not willing to take the credit risk. So the oil stocks were depleting, and the refinery went into effectively shut down with the seizure. But there's remember, we're talking about the excess policies here. They attached north of $250 million, and there's no suggestion here that Carlyle had more than $250 million worth of oil. at the time that the refinery shut down that would give rise to a claim.
But isn't that an
against the
accounting
excess.
issue really more appropriate for trial as to whether or not the excess layer was touched? I mean, how can we make that determination on this motion?
Well, there's no need to, Your Honor. There's no need to make that motion, that determination.
But that's your argument here, right? So isn't that really an issue? If there's a taking after August, after the bank accounts are frozen, after Carlyle says stop doing this, and no payments are forthcoming as they were prior to August, wouldn't that just raise a triable issue as to whether how much was spent or how much plaintiff's entitled to, and whether or not the excess is triggered?
Carlyle, I don't understand Carlyle to have sued on the basis of losses only after August. All of the losses here occurred because Carlyle paid for shipments that arrived before August and then were not repaid later. The oil was refined. I come back to the point that the question is whether the oil was lost and when it was lost and how it was lost. This was never an issue of theft that occurred after. It was always a question of before. The question is refining the oil, and that's how Justice Sherwood correctly defined the question here based on the complaint. Is refining the oil, is that theft? And their own witnesses concede that no, what happened here with the refining of the oil was not theft.
But
I would point out,
am I mistaken, counsel, that Samir continued to use Carlyle's product all the way into late 2016, which is well after the bank accounts were frozen. Am I wrong about that?
Well, that's true, but the question is how much oil was lost after August, because the shutdown of the refinery occurred at a time when it was already running out of oil. So you have to remember there was also commingled oil in there. Carlyle didn't purchase all of the oil that was delivered. There were other oils in there, other cargoes in there. It may have been.
How are we going to decide that on a summary judgment motion?
Well, I don't think that's an issue on the summary judgment motion here, Your Honor, because the issue is the loss due to the refining, that's the question, of the oil prior to the shutdown. And I point out one other thing, is page 15 of our brief makes clear. There were shortages, major shortages developing before the refinery shut down, and shortages certainly that Carlyle was aware of because they were getting weekly tank stock reports.
Now, isn't it undisputed, though, that there was some refining that was going on after the accounts were frozen? I mean, is there any dispute about that?
Minimal. It was a very minimal amount, Your Honor, and it was nowhere near the 250. They don't allege that it was in excess of 250 lost after the shutdown. The losses occurred here because up until August, Samir had been doing that business with Carlyle and had done $580 million worth of business. They owed $400 million, but the oil was long gone. It was refined as a matter of days after it was delivered. And the last delivery to Samir that Carlyle paid for was July 24th. So by the time of the refinery shut down on August 6th, when its bank accounts were frozen, very little, if any, of Carlyle's oil was still in the tanks. I'd point out that the shortfall.
Okay, can you just finish up because you've kind of used your time?
Okay. Well, I just point out that the shortfall, as we point out in our brief, the shortfall by June 11, which was only 4 days before they came and bought the policy from us, the shortfall between what Carlyle had bought for Samir and that had been delivered to Samir and for which they had not been paid amounted to 1,470,000 barrels. That was up from 369,000 barrels. That was a shortage that they would have noticed in March of that year. So I just come back again to the point that this is an issue about whether the refining of the oil constituted theft. It did not. Carlyle never said to Samir during any of this time, hey, you're a thief. They never said it. You'll never find anything in the record where Carlyle said, you are a thief, you stole our oil. Certainly not before August when the refinery shut down. And Carlyle was completely comfortable with allowing them to use the oil.
I'm sorry, counsel, in September, didn't Olivo send an email saying that we don't consent to movement of our inventory without payment? And couldn't that be seen as withdrawing their acquiescence, or at least raising an issue of fact as to that?
They did, in a self-serving statement that was, again, closing the door after the horse had bolted. But I point the court out to the response he got to that, which is on the record at 1474, which is a letter from Samir. The only evidence of what Samir was thinking at this time was that letter, which was the response to them. And it says, please note, in accordance with the agreements and procedures, and in a total spirit of good faith, Samir sold the commodities in order to pay Vermilion, that's the Carlyle entity, in the normal course of business, Samir is recognizing this was the normal course. They had fully intended to pay. They sold the product so that in the normal course, as everyone expected would happen, they would have the money to pay. And as they say in this letter, you read the whole thing for yourself, you'll see they're very apologetic. They say, look, we intended to pay you. The government seized our bank accounts. And that's the loss. That's the proximate cause of the loss here, was the government seizing the bank accounts. Had nothing to do with the physical oil.
So which means that Samir couldn't pay once their bank accounts were frozen. So continuing to use and sell Carlyle's product after that sounds to me like a taking of some kind.
Well, the only oil that was insured under our policy was the crude oil that came in, not anything after that. The crude oil that came in, I take that back. I will stand corrected that there were some refined products that were given to Carlyle as a swap in June, months before, but which would have been sold long before the shutdown of the refinery, the seizure of the bank accounts, which could be considered to have been insured under our policy. But we insured the crude oil that was coming in and used as the feedstock, and which through the course of business and with every intent and consent of Carlyle was refined by Samir. And remember, we insured the oil from physical loss. We didn't insure Carlyle from financial loss, and that's what they suffered.
Thank you very much, Mr. Woods. Mr. Yohai, you have a couple minutes.
Yes, first of all, there was $87 million in refined products that was taken also, which Mr. Woods came to at the end.
If we make the distinction that we have been discussing between before and after the frozen accounts, do you still have a viable claim?
I believe we do, but let me point to first record at 558, which is a May email. Justice Singh, you're focused on a September email. I have a May email from Mr. Olivo to Samir saying, in reviewing the last inventory report, it appears that Samir has removed product from its tanks in excess of what is owned by our fund. This situation needs to be remedied immediately, as we have not agreed to advance unsecured credit to Samir.
And so what happened after that?
They remedied it.
Payments were made.
They remedied it immediately. And the understanding was that was not to happen again.
So it sounds like there was a course of conduct. They continued acting in this manner. You would object, and payments were made. No.
No, because when we object, when somebody takes something without your consent, they take it and then you object and then they pay you back. You don't expect that to happen again or call that a course of conduct. I call that taking without possession. Of course we objected. How can it be a course of conduct? The cases of this court on course of conduct find that it has to be clear. It has to be a clear waiver. There's no clear waiver here. We objected. If this ever happened, we objected. And again, this is summary judgment, and that's the key point. As to the refined product, again, how can you refine already refined product if that was the theory that somehow, the product was, taken so that they could refine it? It was already refined. They took that product too. Moreover, the portrayal of them needing the money to pay us back from refining the product, that's not how this deal worked. Samir's principal was worth $8 billion. He was one of the richest men in the world, Sheikh Alamoudi. He also spent time, frankly, in jail after this in terms of theft. But the point being that was never the arrangement. Others may have had an arrangement that was more like a financing. Our witnesses testified Carlyle's position here was that it made the contract such that it couldn't be a financing. They weren't willing to take credit risk on Samir. They wanted their money up front. And that's why each of the contracts carefully says, this is a true sale, we own the commodities, and you have to pay us first. The MCTA at paragraph 3D and 3E explicitly says, you have to pay us before you take title to it. And again, this is the point.
Well, after this May email, from Mr. Olivo to Samir saying, this is not what we agreed to, pay us immediately. What happened after that? I mean,
Yes.
did this continually happen, or
No.
would everything
It's-
go back the way it was supposed to be?
It's rectified, that is. And then on June 16th, the day after Mr. Woods' comment, the day that the excess policy is to incept, there's an email from Mr. Suvagaya saying he's looked at all the deals and we are absolutely paid for everything that we had advanced as of June 16th. Okay? So that's the point. It wasn't a course of conduct, and the client was constantly looking at this to make sure that the deal was supposed to operate as they understood it, meaning that they were supposed to be paid in advance. If they took it out on the day that they took the product out, they were supposed to be paid, not 30 days later. There is testimony that this was not a credit arrangement for 30 days or 60 days. That was not the deal here. Okay, ever.
Okay.
Ever the deal.
Okay, can you, anything further? Because we've kind of run out
I
of our.
understand.
Does anyone else have any other questions?
No.
Okay, I think we got the basic points. You've answered many of our questions, all of our questions. We thank you both for coming in, and have a good afternoon. We will certainly take another look at all these papers.
Thank you,
Your Honor.
The next case is Bergassi Group versus Allied World. The appellant. You may begin.
Yes, sorry about that, Your Honor. My name is Michael Tricarico. I represent the appellant Allied World Insurance Company in this dispute. This is an appeal of the trial court's January 15, 2020 decision, which permanently stayed an arbitration that was properly commenced by Allied World against respondent Bergassi Group LLC. The trial court decision was materially wrong in several respects. First of all, the agency agreement between Allied World and Bergassi included a clear intent to arbitrate, and under both the Federal Arbitration Act and under New York law, that should have been adhered to.
Well, so that's my question, counsel. Does this agreement affect interstate commerce?
Yes, it absolutely does.
And how does it affect interstate commerce?
Under the standards, well, first of all, you have entities that are incorporated in different states who have entered into an agreement. And again, you don't look at the issuance of the bonds specifically, but you look at the contractual relationship between the parties and what bearing that has on interstate commerce. It doesn't have to directly impact interstate commerce. It just has to bear some relation to interstate commerce. Here, like I said, you have parties that are incorporated in different states. You have an entity in Allied World that, as Bergassi has indicated in their papers that they submitted to the court, it's a global insurance company. The bonds themselves were issued out of a location in Philadelphia for a New York project. So we believe it's abundantly clear that requirement is satisfied.
So if the FAA is applicable under case law, is it the arbitrators who decide the issue or arbitrability?
Yes, the courts in both New York and the federal courts have determined that when you have these gateway or delegation clauses which delegate certain provisions, certain responsibilities to the arbitrators, and it becomes the arbitrator's responsibility to decide those issues. There was such a clause here. That clause was never challenged by Bergassi. In fact, the case law in both New York and the federal courts tell us that you have to challenge the delegate provision specifically in an effort to try and avoid that. Now, we're not saying that there might not have been a situation where if there was fraud in the inducement or a glaring misrepresentation or something like that, where Bergassi might not have had recourse to the courts, but that clearly doesn't exist here. And the principle of delegation of responsibilities to arbitrators, that's the subject of Supreme Court precedent. It's also the subject of Court of Appeals precedent. So I think that is also very clear as well.
Counsel, this is Judge Scarpullo. Why do we have one lawsuit between Allied and Parkside, and now an arbitration? Why are we doing this in two different forums?
Well, we have an arbitration provision which requires us to arbitrate with Bergassi. If we
Right, I agree, but the law of New York is that if it's inextricable, if those arbitrable issues are inextricably interwoven with issues in litigation, that it makes no sense to arbitrate, put it all in one form.
Well,
So why
okay,
is that not true?
so first of all, these issues are not inextricably intertwined. They involve separate agreements with separate parties, separate responsibilities among the agreements. There's case law in New York issued by the Court of Appeals, which we've cited in our brief, which makes it clear, even if you have, if you have related claims with separate agreements, separate parties, separate issues, those don't have to be heard together. In fact, the only authority that the authority that the court relied upon, the trial court in issuing the decision, was a second department case called Jaffe, and in that case, again, second department case, but it's distinguishable on the facts. And this is the case, the precise case that the court relied upon, ignoring all the applicable first department precedent that we've cited in our brief. The Jaffe case involves, different contractors involved in the construction of a house. First of all, they were all a party to the suit originally, but so you have all these claims relating to this same project, this construction project, and one party has an arbitration clause, the other party doesn't. The court determined there that they were inextricably intertwined, the claims, because you have a bunch of contractors who are building a house, and basically who was responsible for that. It's a common set of facts. It's a common set of everything. That all needs to be decided together. Much different from our case here. In fact, in their brief, in their opposition brief, Bergassi even concedes that the determination of the lawsuit, which by the way is no longer pending, and the determination in the arbitration, one won't affect the other, and vice versa. So for them to now claim that they're inextricably intertwined, and for the court to have found that it was just error, because there's nothing to support that assertion. And again, I'd like to get to
words to say, right, counsel?
I'm sorry?
Those are two tough words to say.
Yes, yes, they are. And I had practiced, but I guess I didn't practice well.
Counsel, the Parkside litigation, that was discontinued without prejudice, correct?
Discontinued without prejudice,
So
yes.
isn't there a potential, I understand your argument, it's not there anymore, but isn't there a potential that case could be revived? And then we would have to.
Well, as I indicated during oral argument, it's in the transcript, that's part of the record. Parkside essentially has no assets, so there would be no purpose in pursuing that claim. But in any event, the fact that the case was dismissed without prejudice really has no bearing on this issue, because if you were to hold that, then the next logical extension of that is, if you have an arbitration provision in a contract and there are potential claims that you might want to assert against other people relating to a specific series of events, then in theory you're precluded from bringing those, because you're precluded from bringing arbitration, because you might potentially have other claims against other parties that could somehow be related to the claims that are asserted in the arbitration. That's just that's an absurd result. But that's the situation we're in now. We had commenced the lawsuit before. It's voluntarily discontinued. We're in a position where, yes, we don't dispute, if we wanted to recommence a suit that's voluntarily dismissed without prejudice, we have the ability to do so. But it's no different than standing in a situation where that suit had never been commenced in the first place. And Bergassi doesn't want the court to know about the fact that suit is no longer pending. But clearly, that's an undisputed record from another court. The court has the ability to take judicial notice of that, and it should do that here.
Counsel, isn't your real argument though that it's not inextricably intertwined?
Well, I think it's both, but how could it possibly be inextricably intertwined with a case that is my argument, clearly, and I agree with you. But also, how could it be inextricably intertwined with a case that isn't pending? What's the solution here? Let's play this out to the end game. What are we supposed to do here? We're supposed to, now the court is going to instruct us, say, go sue Parkside again and bring Bergassi in that lawsuit so that all the parties can be in one place. That just makes no sense. The court doesn't have the ability to instruct us who we're going to sue. Basically, it's just Bergassi wanting to avoid the consequences of a clear arbitration provision in a contract. A dispute arises out of the agreement. There's no dispute that there is a dispute or disagreement between the parties. Bergassi contends that term is somehow vague or ambiguous, but they don't dispute that. They're just disputing where the forum where the dispute should be heard. So
okay,
once you have a clear intent to arbitrate, once you have a clear intent to arbitrate, that's it. That's the end game, basically. This needs to go to arbitration. It was wrong for the court to even get involved. It did, but when it got involved, it decided the issue is completely wrong.
Okay, thank you very much. Can we hear from the respondent, please?
Yes, good afternoon, Your Honors, and may it please the court. My name is Tierney Hashemi from the law firm of Gallo, Vitucci, and Clark, and I am appearing on behalf of the petitioner respondent Bergassi Group. I first want to say that Justice Kennedy was correct in each of her findings on the record below. She was correct in submitting that the arbitration clause is ambiguous and unenforceable. She's correct in ruling that the case was.
It is unambiguous, but to me, it seems like a very clear arbitration clause and a very broad arbitration clause. I'm not sure how you can get around this arbitration clause. And I think that this issue shouldn't go to arbitration.
Respectfully, Your Honor, it is ambiguous, and that has come to play in practice, as was.
What about it is ambiguous?
The lack of definitions. You have one conflicting definition insofar as the location of arbitration is supposed to proceed in the city that the company is located. I'm sorry, Your Honor.
You're on.
Whether or not there's an agreement to arbitrate. Where is there any ambiguity in this arbitration clause as to whether or not the parties actually agreed to arbitrate and actually agreed to have the arbitrator determine the issue of whether there's a valid arbitration clause? What ambiguity exists with respect to that clause?
Yes, Your Honor. So the court has required that in order for the arbitrator to determine whether or not a valid arbitration agreement exists, there has to be clear and unmistakable language, and that doesn't exist here. There is no specific, and just taking a step back.
I mean, no offense, but if you're talking about paragraph 12, I mean, it says if a dispute or disagreement arises in connection with this agreement, including a dispute or disagreement as to its formation or validity, such dispute or disagreement shall be submitted to arbitration. So what's ambiguous about that? I mean, whether it should go to JAMS or AAA or NAM or somebody else might be something they can figure out. What's ambiguous about that sentence?
Well, the CPLR provides and the FAA provide for challenges to arbitration agreements based on contract law. And so that's what we're doing here. We're challenging the clause as being ambiguous. And
but I'm just trying to understand how that could be ambiguous. That seems to be, I mean, the way I read it, it's very straightforward. That's one sentence. You got to go to arbitration. You might fight about some other things, even tell you how to choose the arbitrators. I mean, all those things are are contained in that paragraph. I don't see it as ambiguous. I mean, I could understand maybe your argument that it's not inextricably intertwined with the other one. I can see that a little bit more than I can see the ambiguity argument personally.
So to touch on that point, the phrase is dispute, disagreement, and in that section you just read, if a dispute or disagreement arises in connection with this agreement, including a dispute or disagreement as to, quote, its formation, that is referring to the agreement, not the arbitration clause. And that's why this challenge is appropriate before the court.
Why isn't that all part of the agreement? The arbitration clause is part of the agreement. I mean, it's so broad. There's no carve out here. Any dispute or disagreement as to the formation and validity, how could that not include the validity of the arbitration clause?
Because the court has required that incorporating the arbitration clause in that challenge requires unmistakable and unequivocal language. And that's not here. It does not say including the arbitration agreement or the arbitration clause. It says this agreement.
Okay, can I suggest that we go on to another issue? Because I think, and I personally was a little bit more concerned about the connection between these two litigations. And as just one of my colleagues asked, does it make no sense to have one litigation and one arbitration when they're so, connected that maybe they should all be heard together. I know that other case has been discontinued without prejudice, but the truth is it doesn't exist anymore. So what about that? I mean, do you think they're inextricably intertwined, and what can we do about it if they've discontinued it?
Well, we do take the position that they're inextricably intertwined, Your Honor. As far as the discontinuance without prejudice is concerned, when the court heard this application and when the motion was marked fully submitted, that was unknown to the parties. So as far as the record before the trial court is concerned, that discontinuance is not incorporated in the record, and in fact, it's part of this motion to renew and re-argue, which we address in our brief.
Well, we're allowed to take, I think, judicial notice of the status of, pending cases. I mean, those are we're allowed to do that. We can take judicial notice. So.
And I agree with that, Your Honor, but it is a contested discontinuance. When we subsequently looked into this issue, it was revealed that Allied World was in fact securing and proceeding with discovery in that action, despite the quote-unquote discontinuance, which means that, in fact, the case hadn't resolved. And the fact that to date, that Allied World knows that we've made these arguments, and to date, they still haven't filed the discontinuance without prejudice, I think speaks volumes.
Counsel, putting the discontinuance aside for a second, that other litigation has to do with indemnity agreements and enforcement of indemnity agreements. How is that inextricably intertwined with the determination of what has to be decided in this case?
Because with that agreement in Allied World's complaint, they specifically state we conditioned provision of the surety bonds on issuance of this indemnification agreement. So the bonds were contingent on that. They make the same exact claim for damages, the same exact claim for bonds in issue. It's the same exact players. The entire reason why this event or these claims have been initiated is because of an indictment against the Parkside entity.
Issues have to be decided. In one case, you're deciding whether or not there's a valid indemnity agreement and whether or not obligations were triggered under that agreement, which is different than the issues in your dispute, which is whether you acted improperly in submitting them for insurance.
Right, but the basic issues and the basic principles are the same. You have the same parties, you have the same facts, you have the same claim for damages. These matters are so closely related.
May I interrupt you? This is Judge Scarpullo. When you say the basic claims are the same, what basic claims? One litigation has to do with whether you misrepresented certain things when you applied for insurance, and the other one has to do with indemnity. So when you say the same basic claims, specifically what basic claims are you saying are the same?
Yes, Your Honor. It's the claims for damages, right? So regardless of the vehicle by which the contracts by which these claims arose, it is the same catalyst. It's the Parkside indictment. It's the fact that Allied is alleging that Parkside misrepresented something. Allied is alleging that Bergassi misrepresented something in submitting this application. Those two applications and those bonds would not have been written had Parkside not provided the indemnification agreement. And so therefore they're so closely related and inextricably, we're all going to struggle with it, inextricably intertwined, that this matter cannot be dissected from each other. And Allied makes the point that because we take the position that to arbitrate would not resolve the litigation in the Parkside action, that's because they're so closely related that they need to be tried together. They need to be resolved together. The damages address on one another.
Okay, and do any of my colleagues have any further questions? Okay, well, thank you. I think we got your arguments. Counsel, you have 2 minutes to respond.
Yeah, just on that inextricably intertwined situation, there's applicable case law that's directly on point in the First Department. It's cited at pages 27 and 28 of our brief. We have separate agreements, separate parties dealing with different things. Even if they arise out of some of the same events, they're not inextricably intertwined. That's pretty clear here. And the thought that being inextricably intertwined basically means that you would have to have one would have to have an impact on the other. And Bergassi is saying exactly the opposite. And what they're ultimately saying in their brief is it would be more convenient for discovery and things like that. Well, that's not what the law says. And I'd like to also mention that, which we haven't touched on yet, is that this happens all the time, where you have agreements to arbitrate and then you have parties that don't have arbitration clauses. And what should occur and what could have occurred here, but it doesn't matter because the suit is no longer pending, is you can issue a stay of the litigation proceeding in favor of the arbitration. And courts do that all the time, and that's also discussed in our briefing. And as far as this issue of ambiguity is concerned, I'd just like to add that both the FAA, and we believe the FAA applies here, I think it clearly does, but even if you were to conclude it doesn't, and you're looking at this under New York law and the FAA both say that, and the case interpreting the FAA both say that the general presumption is in favor of arbitration, and all ambiguities, if there are any, there aren't any here though, must be resolved in favor of arbitration. And that's the overriding principle. That's the whole purpose behind the FAA. That's the whole purpose behind the language that the courts in the state of New York have adopted that's similar to those cases holding as such under the FAA. So clearly, no ambiguity here, clear intent to arbitrate between the parties. If this dispute was going to go before anybody, it should have gone before the arbitrators. And again, there is no basis for finding these cases inextricably intertwined. And that is even more clear now that the other suit has been dismissed. This idea that we may be getting informal discovery from a party and the party Parkside is irrelevant to whether or not that suit is proceeding. It has no bearing on it whatsoever. I'm not handling that suit, so I don't know the exact status of it, but I do know that it remains dismissed without prejudice, as the court can tell clearly by looking at the records. So unless there are any other questions, that's all.
No, I think we got your arguments. Thank you both very much for coming in this afternoon. Okay.
Thank you, Your Honor.
Thank you.
All right, and the last case for oral argument today is Lewis versus Hallan Construction. Counsel for defendant Hallan.
Good afternoon, Your Honors. May it please the court. My name is Peter Simon, and I represent Hallan Construction in this action, the appellant here. We believe that the court below incorrectly decided several issues in this case, and I'd like to go through them in seriam. Let me start out by saying that this is not a run-of-the-mill prevailing wage claim, as the plaintiff has argued up, down, and sideways. It does not have anything to do with unpaid wages or failure to pay workers for the hours they worked or failing to pay overtime.
Well, it was that whether or not they were paid for the work that they were being done. The claim, I think, is that some of these people had a certain title, but they were doing, they were laborers, but they were actually performing operating engineer work, and they were getting paid as laborers. So that was, the way of saving wages. So I know it wasn't just a non-payment, and I believe that the plaintiffs haven't contested they actually got paid for the right number of hours. They're saying they didn't get paid the right amount or on the right, level for the hours that they worked.
You are correct, Your Honor. It does involve local 731 laborers who claim that they performed work out of their jurisdiction or performed tasks that belonged to the jurisdiction of local 15 operating engineers. Here, Hallan and the unions, as well as what you just correctly noted, the plaintiffs all agree that they were paid correctly. There was no outstanding amounts that were owed. The single issue here is whether these workers performed work out of their jurisdiction, and if they did, whether they should be paid for that work. Now, plaintiffs argue that 220 applied, and the court below agreed with them and found that it did. That, respectfully, is wrong. The operating language in 220 refers only to public works contracts, and it does not implicate Con Ed or Nat Grid contracts, which are at issue here.
Counsel, can I stop you there? Is that correct? Doesn't the administrative code require compliance with 220?
No, Your Honor, I don't believe it does. 19142, the operative language of that says the prevailing scale of union wages shall be the prevailing wage for similar titles as established by the fiscal officer pursuant to section 220 of the labor law paid to those so employed. That language is materially different than the language in 220 referring to prevailing wages. If you take a look at 220, 3A, that refers specifically to the prevailing rate of wages. And if you go and take a look at the definition section of 220, pursuant to 5A, it says the prevailing rate of wage. So you have in 3A the same language as you do in the definition. However, when you go to 19142, and I'll go back to 3E, which contains that identical language, this refers not to the prevailing rate of wages. It says the prevailing scale of union wages. That is not the same as the prevailing wage. What this says is that the prevailing wage is the scale of union wages, and it is respectfully argued here that that is a misinterpretation by counsel and by the lower court. The language in 220E is identical to the language in 19142. And E is not a reference to a mandate for adherence to the schedules that are promulgated by 220. It is a reference to the responsibility and obligation of a utility company to keep proper original payrolls. And if you look at section E, it starts with utility companies and their contractors and subcontractors who, and then it goes on to under local law or ordinance are required, etc. Go down to the next, shall be required to keep original payrolls. There is nothing in this section that requires us to keep to the schedules that are promulgated by the court.
This is Judge Scarpula. What about section 19142 of the administrative code, right? Which requires you to do certain things. You're putting gas mains in, right?
Yes.
And you have to get under the administrative code that administrative code, under that piece of the administrative code under which you are working, incorporates 220 of the labor law, right?
Respectfully, no, it does not. It refers, again, it's the identical language to 220E, and it refers to the prevailing scale of union wages, not to the prevailing rate. That's a critical distinction here that I think is lost in the arguments that are being made. It is frankly wrong to make the argument that the utility contractors under section E are mandated by 19142 to adhere to the schedules that are promulgated by 220.
Well, wait a second, isn't that what the plaintiff is alleging? That it's the prevailing rate, not the prevailing scale?
The plaintiff is arguing that it is the prevailing rate, which is in 220.
So that's what the plaintiff alleges, and if you disagree with that characterization, then that's a motion down the line, right?
That's what's at issue here, because the lower court found that these contracts brought us within the ambit of 220.
So you're saying that because of the way you're defining it, that you don't even get within the ambit of Labor Law 220.
Correct.
And that's the first, threshold issue we've got to determine here.
Exactly, Your Honor. And once you get to that, then you realize that it's a classification issue, and this has nothing whatsoever to do with 220. It has everything to do with 731 and 15's the agreements between the collective bargaining agreements between Hallan and those two to make a determination as to which union had jurisdiction over these tasks.
Okay. Let's see. You have actually used your 8 minutes. Can you, how about if we go, because I think those were important arguments. Let's go to the other side. You'll have a few minutes to respond, okay?
Thank you, Your Honor.
Thank you very much for the arguments. Mr. Murphy, we'll hear from you.
Yes, thank you, Your Honors. May it please the court. James Emmett Murphy from Virginia and Ambinder for the plaintiff class respondents. I frankly can't quite understand what the argument is that appellants are trying to make with respect to there being some fundamental difference between the term prevailing scale and prevailing rate. The contracts that Hallan entered into with Con Ed specifically say that the wages that are to be paid on any work that requires a street permit, which this work clearly does, are the wages that are promulgated by the controller under 220.
We can't hear you, Mr. Murphy.
I'm sorry.
Oh, we couldn't hear you for a minute. Now I can hear you. Whoops, now I can't hear you.
Clearly.
There's something the matter with whatever your connection is, because you're going in and out.
The best. Am I?
As far as I can tell, you're going in and out. I think that's happening for my colleagues. So,
okay.
Mr. Murphy, you can call in. There's a line you can call in.
Thank you.
there should be someone from tech on here who sees that there's an issue.
I should be on.
I think.
No. Hello?
Say something, Mr. Murphy.
Yeah, we can.
Yes, hello.
Okay, we can hear you.
We can hear you.
Okay, I apologize for the technical difficulties there. The line.
Excuse me?
I'm sorry.
I'm getting a bad echo.
Yeah, there is a little bit of an echo, but I think we're going to have to just accept the echo for a while. Otherwise, we have to. We'll just have to do that.
I sincerely apologize for this. This
probably
hasn't
has
happened
two
to me
different devices
on. I've muted everything that I possibly can.
Okay.
The section 19142 of the Administrative Code specifically requires that on any project where there is a street use permit, which these projects unquestionably required, that the wages to be paid are those set forth by the controller under Labor Law Section 220. The contract that Hallan entered into with Con Ed specifically says that the wages to be paid to those workers are the wages that are required to be paid under Labor Law Section 220.
So, counsel, this is Judge Scarpula, and what the Hallan is arguing is that you're not disputing the prevailing, that you weren't paid that wage. You're disputing that you should have been on a different scale, that your workers were doing work that's on a different scale. And that is what counsel is saying is not covered by the labor law.
So the
how do you
easy
respond
answer
to that?
Sure. The easy answer to that would be that if a worker could not bring a claim for underpayment of prevailing wages, so long as they were being paid a prevailing wage, then a contractor would be free to enter into a collective bargaining agreement with whatever the lowest paid trade is. I believe at the moment it would be a roofer, and pay that roofer's rate to everyone, regardless of whether they were a machine operator or a sky crane operator or an elevator constructor or any other highly paid trade. They could say, okay, we're complying with our collective bargaining agreement that we have with the roofers union that lets us pay, $25 an hour instead of the $100 an hour that the sky crane operator is supposed to be getting.
So you're saying that counsel, that Hallan is too restrictively interpreting 220 of the labor law.
Yes, absolutely.
It covers both scale. It covers being put in the wrong scale and being paid $12 instead of $25.
Wrong rates.
That's correct. And this exact issue was before the court in Dabrowski versus ABAX, which is a case that was cited in the papers, where Judge Gish was faced with a circumstance where a company was signed with a wildcat union that allowed them to pay $15 an hour under their collective bargaining agreement. They were doing asbestos abatement work that required a higher payment of prevailing wage rates. Workers sued for the underpayment, the difference between what was required under the prevailing wage schedule for that trade work and what they were actually paid in accordance with the collective bargaining agreement with that wildcat union. This is something that is not novel. This is not something new. And the policy considerations are very, very obvious here. If any contractor wanted to underpay prevailing wages, all they would have to do by defendant's logic is to sign a contract with whatever the lowest rate is that is included in a prevailing wage schedule promulgated by the controller and pay everyone that rate and say, okay, we don't have to worry about any trade issues. We don't have to worry about any kind of, extra differentials or anything like that. We can pay everyone a roofer's rate and we're fine and nobody can sue us because we're complying with our collective bargaining agreement. That's not how Labor Law 220 works, and that's not how any of the cases that have interpreted Labor Law 220.
Counselor, this is Judge Singh. When I look at 19142, 19142 says that the prevailing scale of union wages shall be the prevailing wage for similar titles. So your position here is that they're doing out-of-title work, so they're essentially, under this provision, entitled to monies for the title of work they're actually doing as opposed to what they're being paid for. Correct?
That's exactly correct.
Isn't that what this section seems to be saying?
That's absolutely what a plaintiff's interpretation of the section is. Yes, and and as I said, I honestly don't understand unless the appellants are arguing that the word scale and the word rate are different words with different meanings, which isn't something that was ever brought up in any of the papers below or before this court. I don't really understand what the substance of the argument otherwise would be.
Are there any, you have a couple minutes. Are there any other points that you need to address? I don't think any of the judges have any other questions, at least right now.
So that's the appeal with respect to the motion for summary judgment and motion to dismiss. The other issue is they've also appealed the class certification motion.
Yeah.
This is again, there's lots and lots of other prevailing wage cases that are always certified as classes. Here in particular, since we have a situation where the company was paying people doing identical work at different rates, which is necessarily a violation of Labor Law 220 when you have two different people and being paid at two different trade rates doing the same identical tasks. We feel that this is just about the best possible case that would be subject for class certification and class treatment. To the extent that the court has any questions further regarding the class certification elements of the appeal, I'd be more than happy to address them. Otherwise, I think we can rest on our papers.
Anybody have any further questions? Okay, thank you, Mr. Murphy. I'm glad you're able to call in and be part of the. That's okay. We can't control it. All right, counsel, you have 2 minutes to respond to anything that Mr. Murphy said or that you choose to respond to.
Your Honor, I'd like to point out that if Mr. Murphy's argument is correct, that every single project that involves opening up a street for the purposes of connecting underground utilities would then fall within the prevailing wage statute. And that, in fact, I don't believe is what the statute stands for. I have not heard a single mention by Mr. Murphy or an argument in their papers concerning the difference in language. Language matters. And when you look at a statute, you have to look at that specific language. And I have not seen a single argument made that the prevailing rate of wages, which is a very specific term in 220, why that's different than the language that's in 3E that refers to the prevailing scale of union wages. I'm not a single argument against that. And I'd also like to point out.
Did you make this particular argument to the court in Supreme Court?
Yes. Okay. Judge, I'd also like to point out that with regard to class certification, there should be no class certification here because Hallan established without any question by its own testimony through affidavit and through the testimony of the unions and the testimony of the plaintiffs that they were paid every cent that they were owed. There is not a single document in the record demonstrating that these people were not paid what they were supposed to be paid.
Well, I mean, that's why they're bringing the case. They're not saying that they were paid everything that they should have been paid. They're saying if they were doing labor or work, then they would have gotten paid for the hours they worked for, but they're claiming they weren't doing labor work and they were working, doing other kind of work, the engineering, operating engineering work. And so they're not saying they got everything that they were entitled to.
Which is directly contradicted by their union.
Do any of my colleagues have any further questions for Mr. Saman? All right. Well, thank you both very much for the arguments.
Thank you, Your Honor, for the time.
We appreciate that. And this now concludes oral arguments for today, and court is adjourned. Thank you all.